in Malaysia, what we found was that the process of lawmaking is very non-consultative. Organizations such as the public, civil society and the Attorney General are not consulted in the making of new laws. And as a result, the contents of the new laws that are brought in are somewhat problematic. So though Malaysia professes to replace old laws by better new laws, actually what has happened is that the better new laws are quite confusing in the application. And that results really in problems for both the government as well as for the people, because the government itself also has to administer a law properly. So when there's confusion in the law, the ability of the government to fairly administer the law becomes an issue. And on the other hand, the people's rights are affected, because when the law is administered chaotically or arbitrarily, people's rights are restricted, and then there are public protests and so on and so forth. I think the other concern which emerged was the fact that Malaysia still uses archaic colonial concepts such as the sedition concept, which in many of our countries, including in Sri Lanka, have been outdated, have been thrown out. And it is a question as to why Malaysia continues to have a separate legal regime related to sedition when the penal code itself prohibits the propagation of racial or religious hatred. So the question is, does Malaysia want to align itself with the modern developed jurisdictions, with the modern developed laws, or remain in the past? Remain in the past in terms of enactment of confusing laws, or allowing archaic colonial laws to remain in place. Now, an allied concern to this is the role of the Attorney General in Malaysia and in the Malaysian system. One predominant theme we found throughout the mission findings, mission visits, was the issue of selective prosecutions. So while one person is prosecuted by the Attorney General for apparently engaging in seditious remarks, another individual who perhaps, for example, and I take this as an example, burns a Bible or burns a religious document, is not prosecuted. So why is one prosecuted and the other not prosecuted? So the issue of selective prosecutions is, I think, a little bit apparent in the Malaysian practice currently. And the question is whether the role of the Attorney General in prosecuting or refusing to prosecute could be reviewed by the courts. I think in many countries, in many developed jurisdictions, in fact the Attorney General is subject to review by the courts. And the courts have not said the Attorney General has absolute discretion. The very concept of absolute discretion is not acceptable in modern standards, in modern legal standards. And I think Malaysia should actually try and bring the systems in practice in consonance, conformity with modern standards rather than remain in the past.
These issues were prominently highlighted or felt more acutely in what appears to be a post-elections crackdown, and they broadly relate to the exercise of freedom of expression and peaceful assembly. Examples and instances include the seizures of publications, unfair media press coverage, speeches being labelled as seditious, and even assemblies and vigils not being able to proceed, or organisers being charged under the Peaceful Assembly Act. These violations highlight how the government has a wide array of tools at its disposal, using the law, the various laws such as the Sedition Act, the Peaceful Assembly Act, the Penal Code, the Printing Presses and Publications Act, that have been used against human rights defenders, opposition politicians and activists. So what we find is a contradictory situation against public pledges to reform the government, to make it more human rights friendly. For example, public pledges since last year and this year again to repeal the Sedition Act, instituting a new Ministry of Human Rights and Justice. So what we see are two different dynamics happening, and it's in light of this of such dynamics that the mission is conducted to assess the situation, to further document escalation of such cases, as well as to add or contribute to the current momentum, seize on the current momentum given pledges to repeal the Sedition Act, for example.